nobody can dictate your will.
What happens to your life insurance policy? Does it go to the nominee or does it go to the legal heir?
The only thing is that the person who's writing a will should be of sound mind.
Is it a myth that only the rich need to write a will?
No, I think it's not for the rich or the poor. Everybody needs a will.
How can maybe a person who is not capable of being in sound of mind, like someone who might have dementia, uh, how will they be able to pass on their will? It is a basic human want to leave a legacy behind, whether it is a tiny apartment for your child or maybe even a life insurance policy that provides a safety net for your loved ones in case of unfortunate circumstances. But what happens when you don't have a will written anymore? Or what happens to your life insurance policy? Does it go to the nominee or does it go to the legal heir? To clear the air out on all of these questions and to simplify these legal jargons for you, we have today's Quick Take episode. Hi, I'm Ashwati, and today on Quick Takes, joining me is partner at India Law, Mr. Rahul Sundaram. Hi, sir. Thank you so much for joining us.
Hey, thank you, and thank you for having me over. Really excited to be
So,
here.
sir, I would like to kick off our discussion by asking you the first question is that um, in case of unfortunate circumstances, who gets the legal payout? Is it the nominee that receives the life insurance policy payout, or is it the legal heir?
Sure. The Insurance Act is what defines how an insurance company should act in case one of the policyholders, in the event of death of a policyholder. What Section 39 says is that the nominee or a person who has been nominated against the policy should get all the proceeds. Of course, what the Supreme Court and the high courts over the years have held is that the nominee will hold the proceeds from the insurance claim in trust, and he holds it in trust for the legal heirs. So the beneficiaries of the legal policy, the insurance policy, the claim from the insurance policy is held in trust by the nominee for the benefit of the legal heirs. So, can the nominee refuse payment to a legal heir? Surely not. They do not have the rights, or they are not the beneficial owners of the claim, and they will. And in case there are legal heirs who are aggrieved by any acts or omissions on the part of the nominee, they can go to court, and definitely there have been instances in the past. There are set precedents from the Supreme Court and the various high
Right.
courts where the legal heirs have got their right from the policy claims.
Right. So, let's say that if I am writing my will for my future generation to come, so what can I ensure in order to, make sure that the people who receive the will are actually the people that are intended to receive the payout to? Legally, what all steps can I take to ensure that the payout amount goes to the right hand?
Sure. So writing a will, it's pretty simple. It's the Indian Succession Act that defines what a will is. So where a testator wants to have a document which clearly outlines, what of his assets would devolve upon the legal heirs. This is something legal heirs, or even otherwise. Will is the best option. So what is the legal requirement for a will? It need not be registered. There is no stamp duty that has to be put. The only thing is that the person who's writing a will should be of sound mind when he's writing the will, and the will, once it is documented, it should be witnessed by two adults in terms of the execution. And that's all that is required. And of course, subsequently, you can have conducers which can also amend the will. So it's not like once you've written a will, you cannot change it. It can definitely be changed, and as long as it is very clearly mentioned that this is the last will and overrides all the other earlier wills that have been executed by you.
So I just have a follow-up question to that. So does it mean that I can write my will without a presence of a lawyer, or does this need to be registered? If I have written a will, is it a handwritten will is okay, or does it need to
Absolutely.
be registered?
Absolutely. As a matter of fact, the law does not require you to register. There are provisions, as a additional safeguard, you can go to the sub registrar's office and have it registered and have the witnesses sign the records of the sub registry. But that's not a mandatory requirement. It could be a handwritten will, and you could have two people who are not the legal heirs, preferably, sign this document as witness to the execution, and you're good to go.
So, coming to our next question, um, is like, is it a myth to say that maybe only the wealthy or the rich need to create a will? Like, talking about middle class income backgrounds, they usually don't have much property to give away. Maybe they just have an apartment of their own, or maybe they just have this life insurance policy, for example, or a land somewhere that they bought long time ago. So, do they need to mention it in the will that this will go to this person? Or, I mean, is it a myth that only the rich need to write a will?
No, I think it's not for the rich or the poor. Everybody needs a will. Of course, if you do not leave behind a will, the personal laws to the religion that you belong to would take over. Like if I were to pass away without leaving behind a will, my first class heirs, which is my mother, my wife, and my kids, would equally get a share on my property. However, if I write a will, I can actually make sure that the property goes to the person that I intend it should go to.
So my next question is like, let's say that if I want to write my will and I want to ensure that it doesn't create a dispute in my family after I'm gone. So how can I ensure that it doesn't lead to it?
Sure. In case you do not want to disclose the contents of your will to your legal heirs, that's absolutely possible. As long as you have a will that is executed and witnessed appropriately, it may not be disclosed to the legal heirs. Yes, post your death, definitely. You could have. You can appoint an executor of the will who will then or somebody who's known to you who can whom you can confide in can make the your intent post your death known to the legal heirs or people that would be beneficiaries of the will.
Right, right. So what are some of the common mistakes that you have seen people making when they write a succession planning?
One of the most common mistakes that people that make a will is that they do not have a list of all their assets and liabilities clearly listed. Once you know the extent of your assets is when you can actually sit down and prepare um, uh, uh, a will, because otherwise, you might have some bank account somewhere, some demat account, some shares scattered around, and which you do not deal in your will. So to make it comprehensive, you must first of all create a list of all your assets and also your liabilities, because your liabilities will also need to be knocked off against the inheritance that the legal heirs will get. The most important thing to keep in mind when you're writing a will is that you must get a comprehensive list of all the assets and liabilities that one has. So there could be a demat account which you've forgotten, or there are some assets, some jewelry that's lying somewhere in some locker which is not accounted for, some digital assets that you may have, which you may not want to ignore. So get all of that in one place before you write a will. You must also update all your records. In case there are insurance policies, many times what happens is nominees have passed away and we've not corrected those records. So all that and records. New children that have been born into the family, grandchildren, you must make sure that your will updates and is ready to take care of all the extensions or reductions that in terms of the family members that would have happened, and never underestimate the complications of tax liabilities that are there, and you must have a tax advisor or a financial advisor that advises you on the tax matters and what is something that will give you the most benefit here. Uh, the most important part is you must communicate of your intention of how the property will devolve upon the legal heirs or people that you would want to pass on the property to. Have an open communication so that there is no ambiguity, because the disputes would come in case there is ambiguity. The fewer the ambiguity, the better it would be after your death for these properties to be distributed, and greater acceptance.
What legal help should maybe a person seek when they are attempting to write a will?
Uh, well, they're attempting to write a will, like one is definitely the financial advisor, that aspect should be covered. And also, in terms of properties that one has, are these leasehold, what are the leasehold rights that one has on properties, how the inheritance will work there. If there are rental accommodation, what will happen. So these are all issues where one can seek guidance from a lawyer, and definitely it's always advisable to seek legal advice when you're writing out a will, to take care of any eventualities or anything that may go amiss in the long run. So I think a financial advisor and a lawyer should be consulted, and of course there is a lot of information which is there on the public domain, but best to seek advice and move forward rather than rely on what's there in the public domain.
Right. So, moving to a couple of last questions. Let's say that if a person is creating a trust during their
Mm.
lifetime to
Mm.
ensure that the assets have been distributed as they are intended to.
Mm.
So, can the process of probating be avoided here? And is forming a trust better than creating a will?
Sure.
And does
I mean, we all know that
nomination differ? I'm sorry, I'm adding too many questions into one, but I just wanted to add one more thing. Like, does the type of nomination, like beneficial versus trustee, change?
Sure. Trust is definitely better. We all know about how protracted and delayed probate proceedings can be in court, and particularly if they're contested. And the best option, therefore, is to create a trust where, as a settler, you include all your properties in favor of the trust, and you have trustees that will manage the property for the benefit of the legal heirs. So definitely it is a far smoother transition that one can have, and also meets the objects of the settler better, and has legal standing as well. So yes, I think given a chance between writing a will or probably setting up a trust for the properties that you have, I think definitely trust is a far better option.
Right. So one of my last questions, I'm just following up on the one of the first answers that you gave to us, which is that when writing a will, we need to ensure that the person is of sound mind, right?
Yes.
But in life we are often hit with unfortunate circumstances. Like
Mm.
one might fall ill, diseases
Mm.
like dementia, amnesia, or
Mm.
maybe even cancer could affect people.
Mm.
So when they are towards the end stages of life, maybe,
Mm.
or
Mm.
uh, when they are nearing to the end,
Mm.
what can the family do to ensure that the will is in place? Or how can maybe a person who is not capable of being in sound of mind, like someone who might have dementia,
Mm.
uh, how will they be able to pass on their wealth?
My sense is that you will have to be of sound mind, and for medical conditions that it could be schizophrenia. So in the periods of sanity, when the person is of sound mind, he can definitely write out a will. But otherwise, one of the essentials of even any contract is that you have to be a person of sound mind. So that is definitely something which could be grounds of a challenge tomorrow. So in case there is, it could be set aside, and one of the mitigants there would be to write the will early. While you are in a condition and senile decay has not set in. So write a will early, update the wills regularly. Like I said, there could be additions,
Right.
subtractions to the family by way of death or births. So keep updating. Get a medical certificate. Have that in place, so that tomorrow there
Mhm.
is no allegation that you were not in a medical condition
Right.
to record it. And there is also possibility of making a video recording. While you're executing it, please also have a video recording. There is sufficient technologies that have come up, and get it drafted effectively by a lawyer or a financial advisor, and have it witnessed properly. As long as these measures are there, definitely, it'll take care, and do not keep it for the last stage, where senile decay has set in, and this could become an impediment.
Right, right. So, just one last question, follow-up question I had. Like, what if can the person say that, okay, in case I am not in sound of mind or whatsoever, and they haven't been maybe able to decide how they want to pass their will on, can they put that decision off to another family member, or does it have to be someone who is not related? Does it have to
No,
be a lawyer?
unfortunately, you will have to write your own will, and nobody can dictate your will, so to say. But what happens is that, in case I were to die today without a will, then what happens is that you will have the personal loss. So you have interstate succession, which is a succession where the person dies without writing a will. Where in such cases the personal laws would take over. Like I said, if I'm a Hindu that's dying interstate, it will be my first class heirs that will have a right on my assets, and of course the liabilities. So and for a Hindu male, it is the mother, wife, and the children. So each will, and of course predeceased children, so on and so forth. But yes, thumb rule, it's mother, wife, children that will inherit equally from the assets of the father.
Right. Thank you so much, sir. We had a very insightful conversation. I learned about a lot of things, and I hope that our viewers do as well. Thank you so much for joining us on Simple Hair,
Thank
and
you for having me.
we'll be sure to catch up with you sometime soon.
Sure, look forward.